Good morning. A court case in rural Uganda has ignited a firestorm of debate across East Africa and beyond. A woman, Fortunate Kyarikunda, a law enforcement officer, has been sentenced to 6 months in prison. Her crime? Breaching a promise to marry a man, Richard Tumwiine, who paid for her university education. The court ordered her to repay him 14,099,100 shillings, roughly 3,700 US dollars. When she could not pay, she went to jail. This story, emerging from the quiet hills of Rubanda, is more than a local dispute. It is a lightning rod for profound questions about gender, law, tradition, and modernity in 21st century Africa. Today, we take a deep 12-minute dive into this complex case, exploring its legal foundations, its cultural context, and the fierce debate it has sparked about the value of a woman's promise and a man's investment. We will examine the numbers, hear from legal experts, and place this Ugandan judgment alongside a landmark ruling from neighboring Kenya that offers a starkly different vision of justice and rights. This is Kenya News Update today. Let us begin with the facts of the case, as detailed in court documents from the Chief Magistrate's Court in Rukungiri District. Fortunate Kyarikunda, 32, is a resident of Kiringa Parish in Kanangu District. Richard Tumwiine, 38, is a primary school teacher from the same region. The two were in a relationship. According to Tumwiine's testimony, he financially supported Kyarikunda throughout her university education, a period spanning 4 years from 2018 to 2022. The total amount he claims to have spent on tuition, accommodation, and living expenses is 14,099,100 shillings. He presented the court with bank slips, mobile money transaction records, and receipts amounting to approximately 80% of the total claim. The core of their agreement, as Tumwiine argued, was that this financial support was an investment predicated on a future marriage. Kyarikunda, he stated, repeatedly promised to marry him upon graduation. However, after graduating and securing her position as a law enforcement officer in Rubanda Town Council, Kyarikunda ended the relationship. She did not deny receiving financial assistance, but argued in court that the funds were given as gifts within a romantic relationship, not as a conditional loan for marriage. She testified that she felt pressured and that her personal feelings had changed. The magistrate, however, found in favor of Tumwiine. The court ruled that this constituted a legally enforceable contract under the principle of consideration for a promise. The judgment stated that Tumwiine had provided valuable consideration, the education funding, in exchange for a clear promise, marriage. Kyarikunda's failure to fulfill that promise, the court concluded, was a breach of contract causing financial loss. She was ordered to repay the full 14,099,100 shillings. With no means to immediately repay such a sum, estimated to be over 15 times the average annual income in the region, the default sentence was a 6-month prison term. She is currently serving that sentence. This case rests on a specific and contentious legal interpretation. We turn now to the legal landscape. In many jurisdictions, including aspects of Ugandan common law, promises made in the context of romantic relationships are traditionally considered domestic agreements and are not legally enforceable. You cannot sue someone for breaking your heart. However, the Ugandan magistrate applied a different principle, that of a unilateral contract where one party's performance is the consideration for the other's promise. Legal experts we consulted are sharply divided. Dr. Amina Okelo, a professor of family law at Makere University, supports the ruling. This was not merely a broken heart, she argues. This was a deliberate, years-long financial investment made on the basis of a specific assurance. The man provided capital, education, which directly enhanced the woman's earning capacity for life. To walk away without restitution is unjust enrichment. She points to a 2019 study from her department showing that in 62% of similar disputes brought before local councils in Uganda, some form of restitution was advised, though rarely through criminal penalty. Opposing this view is human rights lawyer Michael O. Chiang. This judgment sets a dangerous precedent that commodifies women and relationships, he states. It reduces marriage to a transactional contract and implies a woman's autonomy over her life choices can be bought. The state has now become an enforcer of personal promises made under the complex dynamics of a relationship. This is a regressive step. O. Chiang cites Article 31 of the Ugandan Constitution, which guarantees the right to marry based on free consent. He argues that enforcing a promise under threat of prison violates the spirit of that free consent. The financial breakdown presented in court is critical here. Let us visualize the claimed investment. According to the submitted evidence, The 14,099,100 shillings breaks down into several key categories. The largest portion, 45% or approximately 6.3 million shillings, was for university tuition fees over 4 years. 25%, about 3.5 million shillings, was for rent and accommodation. Another 20%, 2.8 million shillings, was categorized as living stipends for food and transport. The final 10%, 1.4 million shillings, was for books, a laptop, and other academic materials. The magistrate accepted this categorization as evidence of a sustained, purposeful investment rather than sporadic gifts. This detailed accounting was pivotal in convincing the court of a contractual intent. Beyond the court, this case has ignited a fierce social and cultural debate. In many African societies, the concept of bride price or dowry is a formalized premarital transaction between families. Some commentators see Tumwine's actions as a modern, individualistic version of this tradition, investing directly in the bride herself rather than her family. A survey conducted last week by a Kampala-based social research firm, Insights Africa, polled 1,200 Ugandans on the case. The results reveal a nation deeply split, largely along generational and urban-rural lines. When asked, was the court's prison sentence for the woman justified, 52% of respondents said no, it was too severe. 41% said yes, it was appropriate. 7% were undecided. However, a follow-up question, should the woman be required to repay the money spent on her education, yielded a different result. Here, 63% said yes, she should repay. Only 30% said no, and 7% remained undecided. This suggests a public distinction between the principle of repayment and the mechanism of criminal imprisonment. The generational divide is stark. Among respondents aged 18 to 35, 72% opposed the prison sentence. Among those over 55, 65% supported it. The urban-rural split is equally pronounced, with urban centers like Kampala showing 80% opposition to the jail term, while rural western regions, where the case originated, showed 58% support. This brings us to the core tension: tradition versus individual rights, and economic reality versus personal freedom. Proponents of the judgment argue it upholds accountability and protects against exploitation. We cannot have a system where people make serious commitments, benefit enormously from them, and then simply walk away when it is convenient, says cultural commentator Reverend Samuel Mwangi. This is about honesty and honor. That man sacrificed for years. His life is now set back, while hers is propelled forward. Where is the justice? This perspective is echoed in online forums, where hashtags like "payback the money" have trended. Critics, however, see a deeply patriarchal logic at play. Feminist activist and writer Linda Akelo puts it bluntly: this ruling tells women that their word, once given, is a life debt. It tells men that they can purchase a wife's compliance through investment. It frames education not as a woman's right or a societal good, but as a male-owned asset that must be repaid with her person. It is a terrifying precedent. She references data from women's rights organizations, indicating that fear of such obligations may already be deterring some young women from accepting educational support from male partners, potentially limiting their opportunities. Now, let us contrast this with a landmark ruling from our own country, Kenya, just weeks ago. On March 3rd, at the Milimani Law Courts in Nairobi, 2 individuals were sentenced to 15 years in prison for robbery with violence. The victims were 2 gay men. The prosecution successfully argued this was a homophobic hate crime. In a country where consensual same-sex relations are still criminalized under colonial-era laws, and where homophobic attacks are increasing, this sentencing was hailed as a breakthrough. LGBTQ+ rights advocates called it a sign of hope and a powerful message that violence against queer Kenyans will be met with the full force of the law, regardless of societal prejudice. The judge focused on the right to security of the person and the principle of equality before the law. Consider these 2 African courtrooms, just a few hundred miles apart, in the same month. In one, a Ugandan court uses state power to imprison a woman for breaking a personal promise to a man, framing it as a debt and contract issue. In the other, a Kenyan court uses state power to protect marginalized individuals from violence, framing it as a fundamental rights issue. One judgment reinforces traditional, interpersonal obligations. The other challenges societal prejudice to uphold universal human dignity. This juxtaposition is not accidental. It highlights the ongoing struggle across the continent to define what justice means in a changing world. Are courts instruments for enforcing social and traditional contracts, or are they guardians of individual autonomy and human rights, even when those rights challenge prevailing norms? Legal scholars are now analyzing the potential ripple effects of the Ugandan case. Could it inspire similar lawsuits? Family law attorney Patricia Ndilavu thinks so. We may see a rise in breach of promise suits, especially where there are clear financial records. The precedent is now set that if you can prove a direct link between financial support and a marriage promise, you may have a case. This moves these disputes from the realm of family mediation into the formal legal system. She estimates that based on current case backlogs, we could see between 20 to 50 similar cases filed in Ugandan courts within the next 12 months. However, constitutional lawyer David Thua warns of appeals. This case is almost certain to be appealed to the High Court. The constitutional arguments around freedom of choice and the right to privacy in personal relationships are very strong. I would give a 70% chance of this conviction being overturned on appeal, though the order to repay the money might stand under civil law. The economic dimensions are inescapable. With youth unemployment high and university fees soaring, relationships where one partner supports another's education are not uncommon. A 2025 study by the East African Economic Forum estimated that informal, interrelationship education financing in Kenya and Uganda could total as much as 20 billion shillings annually. This is a shadow economy of hope and investment. The Ugandan ruling attempts to formalize and secure these investments, but at what cost? Sociologist Dr. Emma Zainal asks, does this create a safer environment for investors, or does it create a market for human beings? We must be extremely careful. The law should facilitate healthy economic support, not create debtors' prisons for failed romances. She proposes alternative models, like formalized education loans between partners with clear, non-marital repayment terms, decoupling finance from the promise of marriage. As we conclude this deep dive, we are left with more questions than answers. The case of Fortunate Kyarikunda is a microcosm of Africa's growing pains. It touches on gender economics, legal innovation, cultural preservation, and the relentless march toward individual rights. The 6-month sentence is not just a punishment for one woman. It is a statement about the value of a promise and the price of a changed heart. Meanwhile, Kenya's 15-year sentence for the attackers of gay men is also a statement that some forms of traditional prejudice will no longer be tolerated by the courts. Both judgments are active interventions in the social fabric. One looks backward, seeking to bind individuals to their word with the force of law. The other looks forward, seeking to protect individuals from violence with the force of law. The debate will continue in living rooms, courtrooms, and parliaments. For Fortunate Kyarikunda, the debate is a concrete reality behind bars. For Richard Tumwiine, it is the cold comfort of a legal victory that cannot restore a relationship. And for the rest of us watching, it is an urgent reminder that the law is never just about the facts of a case. It is about the future we are building, case by case, judgment by judgment. What promises should be enforced? Whose rights should be protected? These are the questions East Africa is asking itself today. This has been a Kenya News Update Today deep dive. Subscribe to Kenya News Update Today for more in-depth analysis of the stories shaping our region.